is PLD 2014 Supreme Court 532 at paragraph 62.
2014 Supreme Court
532 at paragraph 62.
ये दिखाइए citation 532
Yes, sir.
2014 Supreme Court.
नाम क्या है केस का?
Province of Sindh versus MQM.
ये डिलीमिटेशन वाला केस है।
31 है।
जी सर,
डिलीमिटेशन
जी सर, बिल्कुल। इसका रेलेवेंट पैराग्राफ 62 है सर। और इसमें सर, I don't want to read this whole para to save time, but if your lordship sees about the third line from the bottom of the page, 577, when the main body of the constitution provides for competent legislature, it is not necessary to look into the legislative list. And इस paragraph में फिर कई मिसालें दी गई हैं कि कहाँ डायरेक्ट कॉन्स्टिट्यूशनल प्रोविजन ने ऑथराइजेशन दी थी, कोई कॉरेस्पॉन्डिंग एंट्री फेडरल लेजिस्लेटिव लिस्ट पे नहीं थी. अब इन माय कंसाइज स्टेटमेंट इन पैराग्राफ 31 I've given about a dozen examples. I'm not going to take your lordship's time right now, but para 31 mein I've given a dozen examples where Parliament is given power to legislate on subjects which are not covered by any legislative entry.
So what is the answer over here in this case?
Over here, my reliance will be 191. 191 in the cases of 2, 3, 4, 6, 7, and 175(2) in the case of Section 5.
So how do you read subject to?
Yes, I'll just come to that, but if I may first complete this.
So you're not relying on entry 55?
Entry 55 is relevant as far as 175(2) and the appellate power is concerned. I do not believe that entry 55 is relevant as far as practice and procedure are concerned.
Also not 58.
58 I will be relying upon.
You will be.
Yes, sir. Because my view of 58 is entry 58, and I was just going to come to that, is different from what has been expressed by your lordship. My view of 58 is that after the 57 previous entries which deal specifically with a particular subject matter have been dealt with, 58 is a catch-all kind of provision.
Does it confer legislative competence?
What it does is, sir, it recognizes, it does in the second part. In the first part, what it basically recognizes is that there will be things in the Constitution that directly authorize the Parliament. So wherever it does that, that is within its legislative competence. So that is the part which says, if I can just read, matters which under the Constitution are within the legislative competence of Majlis-e-Shura, Parliament. Now this is meant to cover as a catch-all kind of thing, those direct constitutional provisions.
And then it is followed by 59.
So
sir, we should read 58 totally independently and not give it a restrictive meaning as 59 would indicate.
Exactly. Exactly.
If 58 wasn't there,
yes,
then we are left with 59.
Yes.
Then you are saying you could be in trouble. The law could be in trouble.
Exactly. Exactly.
Otherwise, flesh it out.
Exactly.
Okay.
And your lordship will also see that
surely 59 relates to the other legislative entries.
Yes, 59 deals with when you are covered by a specific legislative entry, it gives ancillary powers, the penumbra around it. But 58 deals with the situations where Parliament has been directly authorized by the Constitution, outside of the list. And then is there also the part that all relate to the Federation. And that is another broader catch-all kind of entry, which recognizes that there may be things that we have missed out in the earlier 57 entries if by reading of the text of the Constitution, it is clear that a particular subject or a particular field would naturally vest in the Federation.
The number of judges in the Supreme Court is fixed by Act of Parliament or presidential order. The number of judges in the High Court is fixed by law.
Yes.
And or presidential order. Law over here would mean what? Would it relate to entry 58 or relates to the Federation?
In 193, the number of judges
in the
High Court?
Where it says law. Now, would it be covered by this latter part or relate to the Federation?
My Lord, I would, for the High Courts, as far as I know, there have been provincial legislation.
That's what the point I'm making. That it does certainly relate to the Federation because under our system, under the Constitution, our Constitution, unlike say the US Constitution, we don't have separate federal court system and state court system. One unified court system applies both federal and provincial law. So insofar as high courts are concerned, in one sense it does relate to the Federation. But as soon as you say that, you remove the provinces. And if you remove the provinces, well, provinces can say, well, wait a minute, I mean, high courts surely have something to do with us. So it's not that simple. You see, that's why I'm saying, that's why I was putting it to you, but I understand you disagree that this is a negative point. You say no, it confers legislative competence. I understand your point.
My Lord, I'm grateful. Now, my submission, of course, is that Article 191 is a standalone enabling provision. Read with the first part of entry 58, it is more than enough to confer legislative competence on part of Parliament. And moreover, the Supreme Court, and I appreciate your Lordship's point about the difficulty of the High Courts, and there is, in a sense, in fact, even our provincial courts, also the CRPC, and there are numerous.
सलाउद्दीन साहब, उसमें देखिए एक और एस्पेक्ट था कि वो जो 191 का इक्विवेलेंट है फॉर द हाई कोर्ट्स, वो क्या है 201 या
जी सर,
उसमें आप देखिए एक और एस्पेक्ट था, उसमें प्रैक्टिस एंड प्रोसीजर की बात हो रही है ना, हाई कोर्ट की प्रैक्टिस एंड प्रोसीजर, लेकिन देयर इन द कंकरेंट लिस्ट there were specific legislative competences with regard to procedure, civil procedure, criminal procedure. So the position of the high courts were, in the context of 201, is perhaps some different from the position of 191, where, as you have noted in your, I think, submissions or something, under 56 Constitution, 62 Constitution, there was specific legislative entry for the Supreme Court, which has been taken away.
Yes, sir.
ये एक बड़ा इसमें एक एस्पेक्ट है ना इसके अंदर कि आप देखिए कि law over there for high courts was not just any equivalent, or I don't think actually there's any equivalent to 58 in the concurrent list, but it could be related to specific legislative competences.
Well,
यहाँ पे एक बड़ा फर्क है ना, आप जरा काइंडली इस पे थोड़ा एक्सपैंड करिए। इशू इतना आसान नहीं है, ये दिस इज अ कॉम्प्लेक्स इशू व्हिच हैज मेनी ramifications.
Well, Lord, the other submission that I was making is that regardless of the case of the High Courts, the Supreme Court at least is undoubtedly a federal institution. It relates to the Federation, and therefore the second part of entry 58 would also come into play. Now, I've already submitted that as far as I am concerned...
Can you repeat this point? I didn't quite get it.
Sir, matters which under the Constitution are within legislative competence of Majlis-e-Shura or relate to the Federation. So, matters, as far as the Supreme Court is concerned and its practice and procedure, etc., that is obviously a matter that relates to the federation. The Supreme Court, there might be a different view or a concurrent kind of thing as far as the high courts are concerned, but at least as far as the Supreme Court is concerned, it is a federal institution, it relates to the federation, therefore it is even otherwise covered by the second part of entry 58.
How will you
The
reconcile?
other issue about the High Courts and the Supreme Court, this problem which we are facing in the Supreme Court, the High Courts, to the best of my understanding and knowledge, and even when I was practicing law, this problem was not faced. The problem faced by litigants mostly was that my case is taking forever to be fixed. But this, I never came across this matter of which cases would suddenly pop up and there would be an urgent application, it would be granted or not granted, and all the other cases would stand in queue, wait for their turn to come up. So would it be correct in saying the high courts are better run than the Supreme Court? I know you may as counsel not be able to say this, but I, as the Chief Justice, may pose this question that, I mean, in Baluchistan I never had this problem. No lawyer even complained or even suggested or ever wrote or application was submitted that of this nature that, you know, my case is being, for bench-specific cases are being made. I mean, there was the criminal bench, there was the constitutional bench, there was the other benches, single judges benches, the company judge, and they would rotate after once in a while, and this issue, at least I as a Chief Justice never faced, and as a lawyer, practicing lawyer mostly in the Sindh High Court, but elsewhere as well, did not come across this problem. Is there such a problem in the High
My
Court?
Lord, to be frank, it depends on High Court to High Court and Chief Justice to Chief Justice and the Chief Justices of this court. And that is precisely the rationale for this law, that it should not depend on Chief Justice to Chief Justice. There should be some kind of framework and structure that is.
And the only other thing which,
committee to committee.
and I would only change it, one more thing I should add. And the other reason why that problem does not exist is because there is a forum of appeal. You're not happy with a High Court appeal, HCA judgment or an inter-court appeal judgment or a judgment, you have a forum of appeal. So that problem does not exist. So here the problem has culminated with a number of factors. Accumulation of powers, the random exercise of power, the non-transparent manner of operating of power, the excessive use of 184(3), going into matters which are very private and individualistic or maybe not within the domain. So a combination of these factors has resulted in this act, in the making of this act, to impute some malafide to Parliament. I think that would not be fair at all, because lawyers have been in the forefront of asking for this kind of, maybe we're left with the mode and manner of who does the law. Even I haven't heard anyone from the petitioner side saying that's fundamentally wrong in this law. So all they're left with is basically, again, competency, who makes this law and who's authorized or constitutionally authorized to make this law. So the problem was created, maybe, and this is Parliament's effort to maybe resolve the problem.
Sir, agree, sir, that our grievances in respect of the High Courts are somewhat less intense because we can always knock on your doors for correction. We don't have that option available here. But just to add on to your Lordship's observation of it may vary from committee to committee, and yes, it may. But the thinking...
Surely the solution is, logically, give the power to the full court, which is where presumably it always lies when the court makes its own practice and procedure. Because you see, you started out with internal independence and all of that. फिर internal independence का तो एक ही logically एक ही हल है ना जी, कि भाई अगर if the court, and I'm not saying I agree with this, because with very great respect, I definitely have a serious reservation with things being imputed to retired chief justices, random this, and with all due respect, sir, this is not proper. We should not impute things to those who cannot defend themselves sitting in open court. We should not do this. But anyway, let me move on. So logically the conclusion is that the matter should be placed in the hands of the full court, because otherwise there is never any internal independence. But the matter doesn't even end there, because full court always decides by majority. So logically, the minority is always in thrall of the majority of the full court. So then logically, the answer would be that the matter must always have unanimity. In other words, each and every one of us will have veto power over anything and everything relating to practice and procedure. The whole thing, with all due respect, in my view, then collapses like a house of cards. This is not the way these things happen. If there is a master of the roster, and I'm again asking you the question that to which, with a very great respect, Mr. Ibrahim did not give an answer. Who, if this law is validly enacted, who is the master of the roster? The creation of Parliament, whether it be a committee of 1, 2, 3, 4, 10, or Parliament. And if Parliament is the master of the roster for practice and procedure of the Supreme Court, where does that leave separation of powers? Where does that leave independence of judiciary? Kindly answer this question.
My submission
First,
is...
would you kindly finish with the competence of the Parliament? If the Parliament is competent, then the law is also competent.
So your short answer to this question, and
as I've understood, your argument is that as far as the practice and procedure is concerned, that entry 58 is to be read with Article 191, and if it is a question of power and jurisdiction, then it will be covered under entry 55. Is that correct?
Yes.
But I have a problem here. The examples you set out in your para 31, none of them use the same language as Article 191. They are all enabling languages that are used in all those articles, where it says by an act of Parliament, by or under an act of Parliament, as may be decided by Parliament. So they are clearly enabling. There is no doubt in any of those articles that you have listed that Parliament can make law. But here you are saying, please read subject to the Constitution and the law as being an enabling power, which is not the same and definitely does not fit into any of the examples you give. So again, the question is how to read the word subject to as an enabling power, as a means of giving competence, because the word subject to is used throughout the Constitution. Whatever you will give meaning to here, you will give meaning to throughout the Constitution. So where is this a law-making power because it says subject to the law? How do we say that this means just an act of Parliament because it includes an act of Parliament, but we won't look at the fact that it includes an ordinance as well, or it can include some rule-making authority which is under the Constitution? How do you address that issue?
I'll come to that. If I can just wrap up this bit, and then I'd pointed out, I made my submissions about entry 55 and 58 and 59. One alternate argument is also, and although I hesitate to make it because I'm on the other end of those cases, but this court has held in two judgments, Fiakat Hussain versus Federation of Pakistan, which is PLE 2012, Supreme Court 224, at paragraphs 33 and 35. And then in the Government of Sindh versus Nadeem Rizvi, that is commonly known as the JPMC case, which is 2020 SCMR, page 1, at paragraph 27. And in those judgments, your lordships have held that Parliament has independent legislative authority to frame legislation in any matter regarding enforcement of fundamental rights, and that is without prejudice, irrespective of any legislative entry. Now, I filed a review against the latter judgment, so I'm hesitant to get a full court finding on that issue. But if that is indeed the correct law.
Surely that case law which, well, the matter is under review, so I myself will not say what I think on that point. But that case law surely does not allow or does not contemplate a violation of some other constitutional provision which is lying at the heart of the Constitution, for example, separation of powers or independence of judiciary. Surely you are not arguing that it goes that far.
Because right now, no. If it violates independence of judiciary, तो then तो, sir, because that is now the second leg I'm coming to.
Separation of powers.
जी, बिल्कुल, equally. What I'm saying is that you might have all the legislative competence in the world. You might have 20 legislative entries in your favor. But if the law that you come up with violates separation of powers and independence of judiciary, then equally it is to be struck down. But the difference between that and competency is that in competency, you don't have to look at the merits of the legislation. When you are gauging it on the basis of independence of judiciary, I would submit, and I'll come to your lordship, that merely exercising that power violates that independence of judiciary. I'll address that as well.
But we are not even clear कि clear competence है कि नहीं, क्योंकि वो subject to है, and you still have to address that question.
जी, मैं ये अर्ज कर रहा था कि अगर if I'm able to convince your lordships that the legislation by Parliament in this case is meant to promote the access of justice under Article 10A, in that case that would be an independent source of legislative competence. The issue of what is to be primary, what is to be afforded primacy, whether the law should rank over the rules or the rules should rank over the law, that I'll address now, sir.
Your answer to the question is that subject to the Constitution and the law is enabling because?
It is enabling because it is a standalone enabling. In my reading of it is, it recognizes 191 recognizes and presupposes the existence of legislative capacity. And
but you would have to go back and see what that legislative capacity is. You'd have to go back and see what legislation we're talking about. It is not necessarily only legislation related to practice and procedure. It can be any other kind of legislation, say on the law of limitation, which says that the Supreme Court can make its rules, but it can't make rules which will then ultimately affect the law of limitation because that is governed by a law. So we go back to look for competence. So again, I take it that there's no clear answer here.
My submission would be that limitation itself is a matter of procedure. It gives rise to vested rights, of course, but it is fundamentally a matter of procedure.
It can be read that here to your right side. Right?
Sorry, sir.
You need to have lights here.
So it means that the rules must be in accordance with every law.
Yes.
It must not be specific to some law. It must be in accordance with Constitution and every law of the country. You should not derogate.
Yes.
तो इस तरह भी पढ़ सकते हैं.
Sir, बिल्कुल.
Mr. Salahuddin Ahmed, here we have specific entries. According to you, 58 is attracted. According to some others, 55 is attracted. But in America, there was no specific entry, and they read into the Commerce Clause. I don't know if you know, the judgment of the Commerce Clause, and gave it a very extremely wide meaning, which probably neither the Constitution makers, though they said that was the intention, but it wasn't reflected in the words. And there is a judgment of this court which has used that argument in, I don't know if you were representing in the Sindh Revenue Board case. I think that was on the case on that.
No,
on
sir,
the Commerce, it was given a very wide meaning because Congress's power was upheld.
Yes, sir. And almost everything was then fitted into the Commerce Clause. Yes,
yeah, exactly. So you've read that judgment.
Yes, sir. Yes. Okay. Sir, I wanted to address now, with your Lordship's permission, the issue of whether Parliament, that if Parliament can make laws relating to the procedure of this court, then whether those laws are to be subservient to the rules of this court. My humble submission is that making the law of Parliament subject to the rules of this court would amount to distorting the plain meaning of the constitutional provisions. Because no matter how liberal or purposive the interpretation, subject to the constitution and law cannot possibly be read to mean that notwithstanding the law, the Supreme Court shall make rules. The constitutional provision clearly establishes a hierarchy. The constitution, the law, and then the rule-making power of this court.
آپ نے جب فرمایا کہ law can repeal the Supreme Court rules, that is, if I understand correctly your position, and do it expressly.
Yes, it can.
Then that, perhaps, that is your answer then?
Yes. Now, there is a contrast that I would like to draw, sir. If your lordship sees...
Would you be taking a lot of time, or how long would you
Sir, about 20 more minutes, sir.
20 more minutes.
I'm
So
so
we
sorry.
can either take a break now, or we can take it out. Let me ask my colleagues then, whether they want to take a break now, or now or later? Now?
Hello.
So, we take a break and 20 minutes, 4:20.
Hello.
420 doesn't sound nice. 430.
421, sir.
4:22.
نگراں وزیر اعظم انوار الحق کاکڑ سے نگراں وزیر نجکاری فواد حسن فواد کی ملاقات. خسارے کا شکار قومی ملکیتی اداروں کے نجکاری کے عمل پر بریفنگ. نگراں وزیر اعظم کی خسارے کا شکار قومی ملکیتی اداروں کے نجکاری کے عمل کو مزید تیز کرنے کی ہدایات. خصوصی سرمایہ کاری سہولت کونسل کا کردار لائق تحسین ہے. نگراں وزیر اعظم. نگراں وزیر اعظم انوار الحق کاکڑ کی زیر صدارت وزارت مذہبی امور کا اجلاس. وزارت کی کارکردگی کے حوالے سے تفصیلی بریفنگ. حج کے حوالے سے اقدامات اور حج پالیسی 2024 کی تیاری کی پیشرفت سے بھی آگاہ کیا گیا. حج پالیسی جلد سے جلد وفاقی کابینہ کو منظوری کے لیے پیش کی جائے. نگراں وزیر اعظم انوار الحق کاکڑ. نگراں حکومت انتخابات کے لیے تمام مطلوبہ وسائل کی فراہمی یقینی بنائے گی. الیکشن کمیشن کے احکامات پر عمل درآمد میں معاونت کریں گے. ذخیرہ اندوزوں کے خلاف مؤثر کارروائی کے نتیجے میں شیخ النوش کی قیمتوں میں استحکام آیا. نگراں وزیر اعظم انوار الحق کاکڑ کے ڈیجیٹل میڈیا کے پروگرام میں گفتگو. انوار الحق کاکڑ سے نئے نیول چیف ایڈمرل نوید اشرف کی ملاقات. پاک بحریہ سے متعلق پیشہ ورانہ امور پر گفتگو. نگراں وزیر اعظم کے نیول چیف کو نئی ذمہ داریاں سنبھالنے پر مبارکباد. امید ہے آپ کی سربراہی میں پاک بحریہ ملک کے دفاع میں اپنا فعال کردار ادا کرتی رہے گی. نگراں وزیر اعظم. اسرائیل کی فلسطینی علاقوں پر شدید بمباری. جبالیہ مہاجر کیمپ میں درجنوں فلسطینی شہید. شہداء کی مجموعی تعداد 500 سے تجاوز کر گئی. حماس کی کارروائیوں میں 700 سے زائد اسرائیلی ہلاک. صہیونی فوج کی غزہ کی مکمل ناکہ بندی کا اعلان. غذائی اشیاء اور ایندھن کی فراہمی بھی بند. غزہ کی پٹی پر اسرائیلی طیاروں کے جارحانہ حملے. کثیر المنزلہ رہائشی عمارتیں اور 150 سے زائد مکانات مکمل طور پر تباہ. 1 لاکھ سے زائد فلسطینی بے گھر. 74,000 کے قریب متاثرین کی سکولوں میں پناہ. اقوام متحدہ. پاکستان میں غیر قانونی طور پر مقیم غیر ملکیوں کا انخلاء. ڈیڈ لائن میں 22